Speaker must consider the version which was submitted to the ECI before the rival factions emerged. If there is a constitution, they seek to amend the constitution, and there are two versions that are placed before the speaker, I can understand that situation. Before the ECI. Even that didn't happen. Quote, in these proceedings, the respondents cannot challenge the organizational election results available on the record of the ECI, as the 10th schedule does not permit the raising of any such defense, is a correct proposition, and I am in agreement with the same. Your Lordships will remember under 29A, 9 Madhads, whenever there was a change in the office bearers, we forwarded to the commission. So he says that's fine. Whether that is in accordance with the 99 constitution, he discards everything. Now come to Madhad 175, which is the problem. In arriving at their decision, the speaker must consider the constitution of the party as well as any other rules and regulations which specify the structure of the leadership of the party, if the rival groups submit two or more versions of the party constitution. The speaker must consider the version which was submitted to the ECI before the rival factions emerged. This is important. Now, there were no two rival factions, rival versions of the constitution. There were none. Admittedly, Madhads, there were no rival factions. 2018 was relied upon, and the court said this is very important. In other words, speaker must consider the version of the party constitution which was submitted to the ECI with the consent of both factions. That's the 2018 constitution. And then it further says in the previous sentence, if the rival groups to submit two or more versions of the party constitution, speaker must consider the version which was submitted to the ECI before the rival factions emerged. They did not submit. They never make an argument in this court, Madhav, that there is a 1999 constitution. Nobody made an argument. In the final submissions before the speaker, they made that argument because it was convenient. And they relied upon this paragraph, which the speaker relies upon, when we know that there were no two versions of the constitution that were submitted by either party. They relied upon the 2018 power structure and acted on it.
Was appointed under the 2018.
When I show you the correspondence, he says, I don't recognize you as a whip. I decide that the whip is Gagavale. Under which constitution was he deciding? 2018? There is no Paksh Pramukh into 1999. The speaker knows it. The election commission knows it. This will obviate a situation where both factions attempt to amend the constitution to serve their own ends. That's the issue. Whereas if there is a constitution, they seek to amend the constitution, and there are two versions that are placed before the speaker, I can understand that situation.
It's before the ECI.
Before the ECI. Even that didn't happen. So how this paragraph came in, Malad, at least we never argued it. Further, the speaker must not base their decision as to which group constitutes the political party on a blind appreciation of which group possesses a majority in the Legislative Assembly. This is what exactly he has done. He says, this is not a game of numbers, but of something more. The structure of the party leadership outside the Legislative Assembly is a consideration which is relevant to the determining of the issue. And he discards that. So, Malad, I just wanted to point that out. But this is the basis on which the speaker, relying on this paragraph, says, I will not look. Para 5. It is first determined, sorry.
Quote of para 175.
I have no idea. I have really no idea. I've been racking my brain, Malad, ever since. I can't find an answer.
Goes this way and there.
No, Milad, I tell your lordships honestly what I think. By that time, the Election Commission's decision had come.
When the judgment was studied. Like two divided groups.
Honestly.
Paragraph, like two divided groups.
Yes.
This paragraph is also divided.
Well, this is my thing. My thinking. The court, the bench knew that there is an election commission decision, and they incorporated something here. But they, anyway, I mean, the decision doesn't help them in any case. Yeah.
See that the bench speaks of proceedings under paragraph 15 of the symbols order,
Yeah,
contemplating thereby that the proceedings had not come to culminated in a
that's
finding.
right. That's right. It hadn't. No.
Just say that the symbols order had come.
They had passed that order, but the SLP was pending.
Particular day.
SLP was pending. It had not culminated. I mean, it had culminated at the level of the election commission, but not otherwise. That's how we are here, Malas. Para 165, Malas, of Subhash Desai. The court says
165.
165. We'll just take that to your lordships. Para 165. I'll read it, Malas, after your
Okay.
lordship. It says, in the proceedings instituted by Shri Sinde, under para 15 of the symbols order, the ECI awarded the symbol bow and arrow reserved for the Shiv Sena to the faction led by him. The petitioners challenged this order before the
Paragraph, the word proceedings in 174 relates to the proceedings as in the special leave petition examining the correctness of the symbols.
That's correct.
That will not be impacted by whatever decision.
That's correct. That's correct.
That he clarifies, including the proceedings.
Yes, it says. We have not expressed any opinion on the merits of that case. So, Maharaj, he lifted that finding of the commission, but in any case, even para 174, 175 doesn't deal with it, Maharaj. So, Maharaj, going back to my submissions, para 5. It is first determined that Shiv Sena party constitution that is required to be looked at for the purposes of identifying the Shiv Sena political party leadership is the 1999 constitution, since that is the constitution available on the record of the commission. Mullahs, how is the speaker concerned with this? If you say that those proceedings are separate, this is separate, then how do you bring in what the election commission has decided? Supposing the election commission's decision is overturned? That's why I said, Mullahs.
Mr. Sibal, 2018 was relied by both parties. But after the chief whip was appointed by the Shinde faction, they also amended the constitution by making himself, or they appointed.
Of this very constitution, 2018.
They created a post.
That's right.
I think some Pradhan.
Mukhya Neta.
Mukhya Neta. So the Mukhya Neta decision, was it communicated to the election commission? No, there is no such evidence.
There is no such. But even if it were, Maharaj, it may.
No, we're just asking.
No.
Because
Not that we know, Maharaj. It's not on the record.
Simple, we could have given some meaning to the first lines of 174, that there are two rival amendments, and therefore which rival amendment is with the election commission will be taken into consideration.
But even then, it couldn't have taken him back to 1999. That's the point.
We are saying that can give some explanation to 174
Yeah.
lines.
Those amendments anyway are 26 July,
And those amendments are 26th of July, Maharaj.
not 21st.
Not 21st of June.
When this disqualification.
This qualification happens on 21st of June. That's the other problem
We are trying to find out a reason,
for 174. I understand.
not the correctness of
I understand.
or the reliability of the amendment.
I understand. Appreciate that. It is first determined that Shiv Sena party that is required to be looked at. Anyways, B. Thereafter, it is determined that the Shiv Sena political party leadership is as reflected in the letter dated 27/2/2018, available with the website on the website of the Election Commission of India.
Correct. This is my leadership.
Kindly see this at page convenience compilation 604 to 606. After having considered the submissions advanced by both the parties on the question as to which is the relevant leadership structure, for the purpose of determination of the preliminary issue, I have come to the following conclusions. The submission of Mr. Kamath that, quote, the jurisdiction under the 10th schedule only mandates a prima facie adjudication as to what is the leadership structure of the political party was at the relevant time. And it does not extend to any inquiry as to whether or not the leadership structure available on the record of the Election Commission of India was pursuant to a validly held election is a correct proposition, and hence I concur with the same. So he agrees that this is the leadership structure, yet he discards it. Petitioner's submission that, quote, in these proceedings, the respondents cannot challenge the organizational election results available on the record of the ECI, as the 10th schedule does not permit the raising of any such defense, is a correct proposition, and I am in agreement with the same. Your Lordships will remember under 29A, 9 Mullards, whenever there was a change in the office bearers, we forwarded to the commission. So he says that's fine.
Whether that is recorded 99.
Whether that is in accordance with the 99 Constitution, he discards everything. Respondent's submission that the said leadership structure of 2018 cannot be considered and relied upon for the purposes of determining the preliminary issue, as the said leadership structure is not in conformity with the constitution of the Shiv Sena, which is in record of ECI, does not arise. At this juncture, what does that mean? And it is a submission which has to be considered by determining whether the said leadership structure can be relied upon for the purposes of determining which faction represents the real political party, which would be dealt with at the appropriate juncture.
29.
That's the 129 Mullah that I mentioned. The only question which is to be determined in the current part of the order is what and who all constituted the leadership structure of Shiv Sena at the relevant time. Then Mullahs kindly come back. No need to read. 101 Mullahs, your Lordships may read. Thus, in view of the above conclusions, I find that the leadership structure of the Shiv Sena reflected in the letter of 27th February 2018, available on the website of the ECI, is the relevant leadership structure, which has to be taken into account for the purpose of determining which faction is the real political party. This is me, Mullah, as Paksh Pramukh.
Even supports me. Majority support.
The question whether which faction is the real party is discernible from the 2018 leadership structure is discussed in paragraphs 112 to 131. So, Mullah, he accepts the fact that the leadership structure is as reflected in the 2018 Constitution and as informed, as was informed to the Election Commission on 27th of February. So how does 99 Constitution come in at all? Because it's not in the record of the Commission. So let's go back to C, para C, Maharaj. Then the Honorable Speaker, completely without jurisdiction, proceeds to compare the political party leadership with the 1999 party constitution and concludes that the political party's leadership structure is not in accordance with the party constitution and consequently discarded the representative of the Shiv Sena political party. Now, how is this part of the jurisdiction of the 10th schedule? Once he recognized that I am the political party, the structure is this, I am the Paksh Pramukh, he doesn't disagree with that, he is appointed under that, then where's the question of going back to the 1999 Constitution? This is not some academic exercise, Maharaj, that's going on. It's real politics. I mean, I give him the symbol. He fights an election on that symbol. He becomes a minister on that symbol. And then the speaker says, no. But I'm not, I can't recognize you even. But Maharaj, if he can't be recognized, that he should be effaced, Maharaj, he should not get this order at all. If everything that was done was under the 2018 Constitution, he can't get the benefit of that Constitution then. He was elected under that. So you discard this Constitution, given the benefit, give one faction the benefit. And then he says, because of the legislative majority, he's the political party. This befuddles me, Malaj, befuddles logic. Then, Malaj, kindly come to D. The speaker completely overlooks the fact that the Shiv Sena legislatures were set up for elections by the very same party leadership, and that under the 10th schedule, the legislatures are bound by the directions of their political party leadership. On an appreciation of the relevant majority amongst the legislators, the speaker holds the respondent MLAs represent the real Shiv Sena political party. So now it's clear, Malaj, he says the MLAs represent the political party. This can't be done, Malaj, under the 10th schedule. And contrary to Subhash.
He is using the Sadiq Ali test.
Sorry?
Sadiq Ali test.
Yes.
Applying the Sadiq Ali.
Exactly.
If there is no clarity as to majority in the political party, we fall back on the legislative majority as a reflection of.
Sadiq Ali doesn't say that, Malaj.
That is what
He said, look at both.
Yes, look at everything.
Yes.
But if there is lack of clarity, then we have to come to a decision.
It's in
So
that.
what we come to a decision
Right.
is more
Yes.
a guesstimation
Yes.
in view of the
Absolutely.
picture in the
Absolutely right. But
Sadiq Ali is decided prior to the amendment.
prior to the 10th schedule. But apart from that, Malaj, what Sadiq Ali says is,
Sadiq Ali has to be understood. When you apply Sadiq Ali ratio, split is recognized as a valid part of the same policy.
yes, you're right.
So that has to be also taken.
But that split, even recognized, allows them as a defense not to be disqualified.
Why?
That's right.
Because if you have a majority in the legislative party, the scheme of 10th schedule as it stood then was considered to be the aspiration of the political party.
Correct.
After the amendment, this defense does not exist. Now, whether the ratio of Sadiq Ali will hold has to be seen.
In my
Post-
turn, I'm going to address that post, my lord, the introduction of the 10th schedule and the deletion of paragraph 3. In our respectful submission, my lord, that legislative majority test and split will have to be relooked at, my lord, because you are promoting something which the constitution abhors. That's, my lord, my submission I'll make. That.
Until and unless there is a merger.
Yes, until
right.
there is a.
But Malaj, let's look at Sadiq Ali. Look, Sadiq Ali, para 3 proceeds with the assumption that there is a split in the political party. Para 3 doesn't talk about split in the legislative party. Para 3 proceeds on the assumption, and that's that Uttar Pradesh case, Malaj. Rana. You proceed on the assumption there is a split in the political party, then the question arises. In Sadiq Ali, they said, when we look at the organization structure, it is so divided that we can't determine which faction. So that was in that context. But in terms of paragraph 3, you still have to show there's a split in the political party.
That this is how the speaker brings in Sadiq Ali ratio.
Yes.
By saying in Sadiq Ali, factually, they were not able to
That's right.
find out
Right.
what was the organizational strength. Why? Because no elections were held.
That's correct.
You see
Your
the
logic is right. Your logic is right.
There was no dispute about constitution.
No.
Here what they said,
They were competing claims, but not that no elections were held. They were competing claims in the organizational structure.
finding was there was no election held as per the constitution.
No, my lord. In fact, in Sadiq Ali, my lord, just to give the facts, the Supreme Court, my lord, categorically says that it is not a case where, my lord, one faction says they have legislative majority and the other faction says we have legislative majority. So, organizational majority. So, it was a case, my lord, that where one faction had both legislative and organizational majority, and the court said it can be a relevant factor. And the court says we are not laying down the law that in a case where there is a complete divergence between one faction enjoying the legislative majority. Yes, no, so therefore,
we are aware of that.
yes, para 26.
Issue in Sadiq Ali was more relevant is why they were going to the legislative majority
Yeah.
when the question was to see the the party majority.
Yes.
Because the facts were not clear as to what was the majority in the party. So they fell back on the legislative majority
In fact,
as a convenient tool.
Well, let's for a moment accept that, Malad.
both were looked.
No. My lord is saying something else.
So Sadiq Ali.
Yeah, they looked.
Organization was
Yeah. He's not. My lord is not saying that he wasn't looked at.
Majority was there, sir.
Uh,
And legislative majority was also there in Congress.
yes.
And therefore they said that this faction seems to have the
Yes. You're right.
This was not a case that there is
Ah.
some kind of a problem like organization majority.
Yeah.
In fact, it makes it very clear in paragraph.
दे दो paragraph 30.
16.
In Sadiq Ali, Congress yes,
Right.
and Congress
Get out
had majority in,
Congress versus Congress.
yes, and Congress who had a majority in the organizational wing as well as legislative. So they looked at both, Malad, but this exercise that he has done.
They looked at both and they said that the organization is so disorganized, it is very difficult to
No.
rely on it.
Para 30 doesn't say that, Malad. That's,
Let us see.
we
That
stand
is what they
corrected.
say.
Para 25.
Pahले para 25.
माननीय सुप्रीम कोर्ट में वरिष्ठ अधिवक्ता द्वारा रखी गई इन दलीलों के बाद अब शिवसेना का एक कानूनी विवाद बेहद महत्वपूर्ण मोड़ पर पहुंच चुका है। इस पूरे मामले पर माननीय सर्वोच्च न्यायालय के कानूनी दृष्टिकोण और तत्कालीन विधानसभा स्पीकर के फैसले को लेकर आपकी क्या राय है, हमें नीचे कमेंट्स बॉक्स में जरूर लिखकर बताइए। जय हिंद दोस्तों।